Welcome to the law office of Ken Schwartz. I am Ken Schwartz. I'm an attorney and I specialize in distressed properties. What we're going to talk about today as an introduction to a multi-part series on distressed properties is what is a distressed property? What do you need to do when you recognize your property is being distressed? How do you deal with lenders and servicers and other folks like attorneys who may be trying to enforce debts against you? What to do if a process server serves papers upon you seeking to foreclose upon the property? What repercussions, what effect can that have upon your house? How much time, for example, can you remain in your house after being served with foreclosure papers? And what about if you want to retain your house or sell your house? Would you still have the ability to do that? And if so, can you correlate that to some form of financial gain? So we're going to get into all these things, not necessarily as part of this introduction, because that would be a lot to say in one place, but we're going to get to it as part of this multi-part series. So let's talk about what is a distressed property first. Well, and we're going to confine our conversation to residential properties, not necessarily commercial properties, although many of the concepts that we talk about could apply to commercial properties as well. So, to begin, what is a distressed property? Well, a distressed property is a situation where the liens on the property are greater than what the property is worth. What is a lien? A mortgage is a lien, a judgment is a lien. Things that are attached to the property, financial obligations that are associated with the property, those are liens. Or you could have a situation where the liens are not greater than whatever the property is worth, but the mortgage hasn't been paid, and therefore a secured lender, a mortgagee, has the right to bring a foreclosure action against you. What is a foreclosure action? It's a lawsuit. It's a lawsuit to sell the property to satisfy the debt. So now, most of the time when folks come to me because they feel the situation is out of control, it's because a lawsuit was started, a foreclosure action was started against them. How do you know if a foreclosure action was started against you? Well, for one thing, a process server, a person, usually comes to your front door and says, here are papers. Here are papers, and it's a thick set of papers which will talk about you, the property you own, and the fact that your lender is seeking a judgment in foreclosure. Now, the first question that folks often ask, how long can I remain in my house after being served with a foreclosure? Do I have to get out the next day, the next month? How long can I stay? And the answer is that it will vary from county to county, but as a rule of thumb, even if you do absolutely nothing in response to a foreclosure action, you can normally remain in your house, or in other words, the time that passes between the start of the action when the papers are first served and the sale at the courthouse steps is generally 2 to 3 years. Now, if you defend, and you do have defenses, because just because you show up and say, hi, I'm here, I'm defending, doesn't necessarily mean you have defenses to raise. But if you defend, and in many cases defenses do exist, then 2 to 3 years could become 4 to 5 years, or perhaps the lender doesn't win. It all depends. Nobody likes that word, but very often it does depend. Now, when you're served with a set of papers in a foreclosure proceeding, the last thing you want to do is let it go and not oppose it. Why? Because if you do nothing and you allow the case to proceed, then the lender will get its way. Getting their way means that there is no opposition. You are not entitled to raise defenses. If you default, if you don't serve an answer, if you don't notify the court, if you don't notify the other attorney, then the lender gets what they ask for, and the court rules are worded so that you are not allowed to raise any defenses in the future, generally speaking, and there's always exceptions. A few things that you do want to think about in the process. Do I want to keep my house? Am I better off keeping my house at the end of the day? Am I better off working out what's called a loan modification agreement? And there are all sorts of rules that govern loan modification agreements and what lenders and what we call mortgage services are required to do, how that can affect you. Or do I want to defend the foreclosure to make sure that the lender doesn't take what's called a deficiency judgment against me? One of the things that folks often raise, appropriately so, is that if I'm getting sued, can the lender take a money judgment against me, and will that affect my other properties? These are the kinds of considerations you have to look at when you're being sued in a foreclosure. And as part of this multi-part series, we are going to get into every one of these considerations. So please put your feet up, have a seat. There is no fee for this consultation. This comes free of charge. I will see you in a few minutes.